Court Department. Hear ye, all persons having business to before this court, draw near to the defense, they shall be heard.
Thank you. Please be seated. The first case on for argument today is case 292, an accounting by Cheryl M. Pastor. We have a video appearance on this.
Good morning, Your Honors. May it please the court, my name is... I'm sorry?
Good morning, counsel. Proceed.
Thank you. My name is Lori Perlman from Falcon, Rappaport, and Berkman, and I'm here on behalf of Appellant Diana White in her individual capacity as a beneficiary of the reserve trust of her father, John Morrison, and also as the executrix of the estate of her mother, Arlene Morrison, who was also the primary beneficiary of that residuary trust. There are two issues that have come up on this appeal. The first is a construction of the buy-sell agreement, and the second is whether the trustees, who are also the executors and have succeeded to the estate of the decedent without obtaining a final accounting, have the obligation...
Can I interrupt you, counsel? Correct me if I'm wrong, but really the main issue here is the valuation of these shares of stock, right? And how they should be valued, right? Okay. It seems to me that paragraph 5 of the shareholder agreement, whether we're talking about paragraph 5A, B, or D, all of those paragraphs seem to apply to a sale, a purchase or sale of the shares. So it almost seems to me like none of those paragraphs apply to the pure valuation of the shares.
Well, the question is answered by looking at the agreement as a whole. This agreement has a requirement that and this is in Article 3, that anyone who holds shares must sell those shares to the named individuals.
And then there's a procedure though that is to be followed for that to happen. Was that procedure followed? Like, did the involuntary transferees offer the shares for sale within 60 days?
I am not aware of that. I came into this as counsel after quite late in the game. I do not know if they were formally offered or if they followed the instructions that were given. But if they did not make a formal offer, no one objected to them failing to follow the procedural aspects. That doesn't take away their responsibility to follow the valuation that is set out in Article 5. So this agreement, Article 5, sets forth very clearly that there's a series of two valuations. One is very clearly accepted from Article 5, and that is an involuntary transfer and an involuntary transferee. The surrogate agreed that this case does involve an involuntary transfer, but said it wouldn't be an involuntary transfer because this is the death of a decedent. But if you go back to the definition section in Article 1, an involuntary transfer and an involuntary transferee clearly includes a shareholder who has, the fiduciary of a shareholder has died. So we've got this situation where a shareholder is an involuntary transferee, and then the question becomes, what's the value of these shares? Article 5A says, value it at 8 times the per share value. And Article B says, cap that at 200,000. So if you take out involuntary transferees, this applies to people, members of the corporation who are selling among themselves. And this was a family corporation, so that makes sense. If the son is selling, if the father's selling to his son and daughter, he doesn't want them to break the bank by buying the family business while he's still alive. Or same for his wife, who was a minority member. She had a few shares in the corporation. Then you get to Article 5 that says if this is an involuntary transfer, then there's two valuation provisions. The first one is value it according to Article subparagraph A, not subparagraph A and B, just subparagraph A. If it said subparagraph A and B, then there would be no difference between Article 5 and Article A. The next provision says, or value it based on consideration received or the credit given. And in order to understand those words, which are not defined in the definition section, you have to sort of flip back up to Article 4. And Article 4 says, if you're an involuntary transferee who acquired shares by legal process or enforcement of it doesn't say those words, but it says if you're an involuntary transferee, you have to make your offer and include in your offer the amount of consideration that you received or the credit that you received plus interest. So that's where those.
Can I interrupt you and ask? Can I ask you another question? Your opponent argues that this objection number 10, was specifically to the trust accounting, correct?
Correct.
Okay. Your opponent argues in the brief that the trust accounting does not contain any valuation of the shares.
That's
because and also takes the position that the trust, I think that the shares are not owned by the trust.
That's correct. The shares are not owned by the trust, not because of some, response that he filed, because there's no such thing in the surrogate's court as a response to objections. But the executors sold the shares and transferred the note to the trust. However, this is a case where the executors and the trustees wear the same hat. The executors did not account first and get a decree by anyone who said, this is set and you did the right thing here, right? So then the trustees come in and the trustees have an obligation to object to valuations in an estate if the estate didn't value them correctly. But here you have trustees who had a conflict of interest. They are the individuals who are paying for these shares out of their own pockets. So they are not going to object to their own trust, their own estate. So that's why these objections were filed. There's also, a trustee doesn't get to just accept what the executor determines is the value of things. If an executor sold a house for $10 and the house was worth $100,000, the trustee has an obligation to go to that executor and say, you haven't collected the correct amount. That's why Objection 10 specifically states that it doesn't just object to the trust. The language of Objection 10 ties into the estate and says that trustees are liable for failing to make sure that they, as executors, collected the correct amount that's due to this trust. And that's a principle that this court has espoused in matter of Dow, that a trustee has an obligation to collect a claim that's due to a trust. Even if that claim is uncollectible in other areas, the trustee has an obligation to go against the fiduciary, because that's their job as fiduciaries, is to make sure that everything was valued correctly.
So, Counsel, is it your argument that there's more than one way to interpret the language here and how it applies to the valuation of these shares, and that way, and because of that, summary judgment should not have been granted?
I do believe that there is only one way to interpret this. I believe that the surrogate's failure to read this contract as a whole left that last paragraph where the surrogate said, I couldn't figure out how to read this within the four corners, but it requires bouncing back up to that Article 4 where it really does say your offer, if you're an involuntary transferee, has to be the consideration. And then you have to jump back up to Article 1 that says you're getting your shares as an involuntary transferee from judicial process, attachment, enforcement of a pledge. So, if the decedent had made a pledge of his shares and pledged them for $100 under Article 5 and Article 4, that would be the value of those shares. The consideration paid or the credit received is $100. That doesn't apply here because we're transferring from an estate. The idea that the surrogate can write in paragraph B into Article 5 or just plunk it into Article 5A and excise the words involuntary transferee is rewriting this contract. And that's not permissible.
Very good. Counsel, do you want to wrap up?
If you don't have any questions, I'm going to rest on my papers. I believe I've made my argument.
Counsel, thank you.
Good.
Good morning, Your Honors. Alan Pierce of Hancock Esterbrook for Respondent Cheryl Pastor. I do believe that there are two alternative grounds here to affirm the order of the Surrogates Court. One being the fact that this amended Objection 10 is specifically, the amended objections that were allowed by the surrogate. They divided them between the estate and the trust. This amended Objection 10 only goes to the trust. The trust has no interest, no valuation of the shares. I pointed, it's a lot of paperwork, but there's nothing about the valuation of shares in this record when you look at the accounting for the trust. So,
is there still a pending objection in Surrogates Court over the estate, the valuation of the shares? I think it was objection number 4.
Yes, Your Honor.
Okay.
There is.
So that's still pending.
It is.
Is it on the same grounds? Is it pretty much the same issue that we have here today?
It is, Your Honor. And appellant counsel brought that up in their reply brief, I guess in response to my argument that, was laid out, and, they were on notice of this. As I pointed out, that was asserted back in 2017 with the original objections, which were separate objections to the estate accounting and separate to the trust accounting. But they were on full notice that we were saying the trust doesn't, and on the summary judgment motion that we made, prior counsel, there was no argument about that from Ms. White's counsel. When they did their amended objections, yes, they have it in there twice, once for the estate and I have no idea why the surrogate addressed it, amended Objection 10 on the valuation of Morrison Realty on the sua sponte and not 4. I don't know. I wasn't counsel at the time, but
kind of setting this merits aside for a moment, is it, and tell me if I'm making an overbroad statement, but are you saying that that the argument isn't at all relevant to the trust? It's only relevant to the estate because it's the estate that owns the shares? Is that not correct?
Well, I think on the papers here in the record, that's the position that my client, the prior counsel for my client took. I think it's the right position that the trust has no interest in the shares of Morrison Realty, and therefore that amended objection should have been dismissed, was properly dismissed. And then I'm happy to address the merits.
Of course, it was not dismissed on that ground.
It was not.
Right.
But that was asserted. It's in the papers. And you know, this issue about these responses to objections is not a proper pleading. Well, I didn't make this record. Appellant made this record before I even got involved in the case. So they put them in the record. I think they are relevant, especially on the idea that as to a legal argument, appellant here was fully aware of the argument that the trust accounting doesn't address this Morrison Realty. And I guess that's why they put it in both. But on that issue. On the merits, I submit that the surrogate got it exactly right here. The language, I mean, the appellant's argument is based on the fact that paragraph 5D of the shareholders agreement is what governs. And 5D only deals with an involuntary if an involuntary transferee shall offer the shares for sale. That isn't the situation here. That's not the facts here, and that's why on the plain reading of paragraph 5D that appellant relies on, it's inapplicable.
So if that's the case, it seems to me that none of the subparagraphs of paragraph 5 apply. I mean, the whole clause of 5 seems to apply to a purchase sale of the shares. You know, specifically 5A and B also seems, references to the purchase price of the offered shares. Am I wrong on that?
Well, I think, Your Honor, two things that appellant's counsel just said this morning I absolutely agree with, and I think they're very relevant. First of all, she said that the shareholders agreement should be read as a whole, and we should look at the intent and what's going on. Obviously the exact words, but also the intent of it. The intent was to make sure that these shares stay within this family unit. The decedent, the decedent's wife, and unfortunately now David Morrison is deceased.
The individuals.
The individuals,
right.
And Cheryl Pastor. So the whole intent of that was to make sure it stayed within that family group, and it was to make sure that that family group didn't, as counsel talk about, don't break the bank. Don't make those family members that are intended to be essentially, I would call them the beneficiaries of that shareholders agreement. So those shares stay within that group. Don't make them pay the higher market value of these shares should the shares end up being transferred to them, sold or otherwise. And so here...
The kind of the bottom line issue is what impact the difference in value has on the residuary trust. Is that correct?
I think so, Your Honor. And to me, as I understand it, was what Ms. White wants is she wants, let's just take Cheryl Pastor. She wants her to have to pay the higher market value of the shares. So there'll be more money to be distributed to her as one of the beneficiaries of the trust. And I assume that that's how I interpret what's going on and why the objection here is so that it'll be...
But certainly, when this agreement was drafted, that could easily have been contemplated. In other words, it wouldn't come as a surprise to anyone that the co-executors here and the trust beneficiaries, that different entities are going to want different valuations. And isn't that why we have the language in here in Article 5 in the subdivisions that explains how we go through the valuations of these? But as Justice Peridano points out, the language seems to talk about on a sale. And I don't know if we're getting caught up in something that maybe we should be caught up in, and that's why I'm echoing the question. If it isn't a sale that we're contemplating here, it's a transfer. Actually, no, it's not. It's a valuation. A valuation of the shares. That's what we're talking about. Not premised on a sale. Do we get caught up in the language that both sides of this argument seem to be focused on?
I don't know quite how to respond to that, but my position is, as I said, their whole argument is based on the app that 5D applies.
Right.
And I don't think it does apply. I think the surrogate clearly got it right that it's not applicable here because we don't fit that language. And I don't think that it's really any ambiguity. I know we're both saying there's no ambiguity, but from different perspectives of
Which means that
whether-
it shouldn't be, if we agree that the appellant's right, then there clearly is an ambiguity to at least discuss. It shouldn't be summary judgment. But you obviously say, no, there is not. And it's-
I
and
don't,
it's clear.
well, I say there's no ambiguity about the fact that 5D does not apply, because we're not dealing with the sale, offering the shares for sale. I haven't really gotten into the question of whether Ms. Pastor is an involuntary transferee. I get the surrogate said she was, and then said, but. We look at the second part of 5D, and that's not applicable here, and I believe that's correct.
So then, if we agree with you, then the question is, how do the shares get valued? And does 5A or B apply, or is there some sort of other methodology that should be used to value the shares?
Well, one second, Your Honor. I believe that 5A and B, the CPA determined that he followed 5A and B.
Yes, he did.
Because he didn't find D to be applicable. We don't have any, we don't have a detailed report from the CPA. We basically have I think a 2-sentence email. But obviously, the CPA made that determination, his interpretation of, and I mean, that's technically that's not my client making that interpretation. We agree with that interpretation, but it was the company's, longstanding CPA who made that determination.
So is your feeling or your interpretation the only construction that can be made with respect to this contract?
I believe it is. I believe that it is when, again, as appellant's counsel said, you look at the agreement as a whole, and the intent of it is to not bankrupt these individuals. The shares are supposed to stay within this family unit and don't bankrupt them. So if they have to now pay $700 and some thousand for the decedent shares instead of 180, that violates the intent of that agreement.
And the agreement is giving us essentially an artificial valuation because there's an arbitrary cap.
Yes.
And the entity, the CPA that was doing the valuation in this case, didn't really do a pure evaluation, but rather simply went through the mechanism and said, there's a cap here, and this is what we're stuck with.
Yes, he did say what the market value was,
Right.
which is apparently the argument appellant's making is it should be that market value, so at the time, but he applied the cap of $200,000, and we submit that's correct.
Very good. Thank you, counsel.
Thank you very much, Your Honor.
Your Honors, I know this is unusual. May I-
No, counsel, there's no rebuttal on this,
Okay,
in this court. Thank you.
thank you.
Case 278, People versus Menudo.
Good morning. May it please the court. Bridget Field on behalf of Mr. Minutullo, I believe. The district attorney's office didn't reply to this brief, so as such, I'll stand on my brief unless the court has any questions.
No
Thank you,
questions.
Your Honor.
Thank you, counsel. 279, People versus Howden. Proceed, counsel.
Good morning. May it please the court. I'm Tanya Plank representing Curtis Howden. Under the standard employed in New York, the Baldy standard, Mr. Howden was denied any kind of meaningful representation. From pretrial motions and the ineffective plea through the erroneous filing of the notice of appeal, defense counsel made clear he didn't have familiarity with the law or even with Mr. Howden's charges so as to render meaningful representation. And under Baldy, even where there's a lot of evidence against the defendant, it doesn't matter that every single blunder might not have changed the verdict. Where counsel makes so many numerous mistakes throughout, it's just a deprivation of meaningful representation.
I mean, really, counsel, your argument, I think, if I understand it correctly, is there were a number of mistakes that were made or blunders or
Right.
missteps that were made along the way. And if we
Right.
analyzed each one of them, maybe that was not sufficient. But in the totality of the
Right.
representation, it failed.
Exactly, exactly. And I don't feel there's a need to really go through all of those. They're all in my brief. I won't waste the court's time and go through them all. But I also just briefly wanted to point out in point 2 in my brief, the judge could have easily prevented all this by just granting Mr. Howden's desire to hire Mr. Kasparek. He already had the attorney hired. I mean, he was ready to represent him. They just needed a 2-week abeyance to get him up to speed. And there was clearly a breakdown in communications between defense counsel and Mr. Howden. It was clearly not a delay tactic. There was really no reason for him to not go ahead. And the court had verified that Mr. Kasparek would represent him, so.
How close to the trial date was that? Remind me in the record that the representation was confirmed?
I think the representation was confirmed.
In other words, the new counsel was actually retained?
I can't remember exactly the exact date. It was.
The Friday before the Monday trial, right?
Okay, right. So it was right. It was.
And that's
it was right
troublesome,
before.
right? Because we have instances where defendants looking to delay trials will very often come up with the
Right.
idea of new counsel needed on the
Right.
eve of trial, which
Right.
causes a lot of inefficiencies and difficulties with the
Right.
criminal justice system.
Right, I understand that. It's just in this case, and obviously in hindsight, the attorney did a horrible job, and Mr. Kasparek would have done a much better job. But that's hindsight, I realize. But it is clear that there was a breakdown in communications. I mean, he said, he's not representing me I don't feel like he's representing my best interest. He just wants me to plea. He's pushing this plea. And he was pushing the plea. I mean, he kept trying to get the client to Mr. Howden to plead guilty, even after the court made clear that it was not going to accept a guilty plea.
It's not even, to me, it's not even clear that this new lawyer was retained that day before trial. He wasn't in the courtroom on
Right,
that
he
Friday
hadn't,
before
I mean,
the
he
trial.
hadn't, yes, he hadn't actually paid for him yet because he was waiting I believe he was waiting for the court to go ahead and allow that substitution before he paid. But the court did verify with Mr. Kasparek that there were communications and that he would be ready to represent him if they took a 2-week abeyance in the proceedings.
Yeah. Well, it's not unusual to have a defendant reach out to an attorney, like I said, close to trial,
Okay.
and ask them to represent him, a retainer discussion to be had, but no money exchanges hands, and then the court is supposed to adjourn the trial, only to find out later that the retainer was not provided, was not met, there was no contractual obligation, and that's
Okay.
why counsel was not in the courtroom likely. But we have your argument, counsel.
Okay, if there's nothing further, I'll rest on my brief.
Thank you.
Okay.
Good morning, Your Honors. Kaylin Porter on behalf of the people. There were a number of allegations of ineffectiveness, so unless the court has any questions on any particular allegation, I'll just ask the court to sort of parcel out those allegations that go to counsel's representation generally, that he was blundering or that he made mistakes. Those really seem to go as to his experience level as an attorney generally versus the representation that he provided to this defendant in this trial. So I'll just ask the court to just take note to separate those types of allegations. As for point 2, I will note that Mr. Kasparek was not hired or retained as of this point. The court did call Mr. Kasparek and verify that he had spoken with the defendant 2 days before he addressed this in trial. As Justice Whalen pointed out, this is the very definition of eve of trial. This was the Friday before a Monday trial. And all of the complaints that he was rendering pertaining to counsel's representation really went to the other case, these new charges that the defendant had incurred during the pendency of the instant trial. So those were, well, it was the same victim. It seemed to be that those were the cases or the allegations that he was talking about. So unless the court has any additional questions, I'll rest on my
Thank you,
papers.
counsel.
Thank you.
Case 280, People versus Parson. Counsel, unmute your, there you go, thank you, proceed.
Good morning. May it please the court. My name is Marcia Hunt, appearing on behalf of Mr. Parson. It is the defendant's position that the court erred in summarily denying Mr. Parson's request for participation in the judicial diversion program. And as such, this matter should be remanded for further proceedings. Mr. Parson made a timely request for participation in this program. The court offered the plea disposition, which ended up being a plea with a parole supervision type of sentence, which involved drug treatment in and of itself. That sentence itself recognized the need for substance abuse treatment in this case. At the time the court took the plea, it could have very easily ordered a substance abuse evaluation to be done in between the date of the plea and the date for sentencing, and the court could have held a hearing on the date of sentencing as to what.
I'm going to interrupt you a second. You said the word could have, okay? And the statute itself talks about the court may do these things, right? So it's in the discretion of the court to decide if it wanted to go down that road towards diversion. Is that correct?
It is correct, Your Honor. My position here.
And isn't it true, let me just stop you for 1 second, that the court gave a detailed analysis of why it wasn't going to do that, didn't it?
It did.
Including, a recitation of some more serious charges that he was awaiting, trial or disposition of, and including, a lengthy criminal history, and the court really didn't shortchange us on its reasons, for not going down the road towards diversion.
May I respond, Your Honor?
Oh, yes.
Okay, thank you. My point here is that the court offering the Willard parole supervision type of sentence in and of itself recognized that substance abuse was an issue in this case, and that substance abuse would be a needed path for Mr. Parson. So I guess what I'm saying is, because after the court took the plea, it could very well have just reconsidered the judicial diversion request at the time of the actual sentencing, as it had a delay for the purposes of the pre-sentence report anyway. Ordering the substance abuse evaluation, which is the people concede in their brief, the defendant brought proof to sentencing, the court could have reconsidered it at that time.
But the court exercises discretion differently in this matter.
Understood.
And it would need to be your point that the court abused its discretion.
That's correct, Your Honor. And based on that is the fact that the defendant did produce proof of the evaluation and treatment at the time of sentencing, and the court, in fact, went along with its agreement for a parole type of sentence, which included the Willard program, which in and of itself is suggestive of a need for drug treatment. And that on that basis, the court abused its discretion.
Thank you, counsel.
Thank you.
Morning, Your Honors. Brad Osler for the people. It's our position simply that People v. Carper, which was this court's precedent from, I believe, 2014, is controlling here. The order of the substance abuse evaluation is permissive, not mandatory, as the court has pointed out. And I think the record is replete with reasons that support the court's exercise of discretion in summarily denying the request. I don't see that it would have been appropriate or an abuse of discretion here.
Thank you, counsel.
Thank you.
Case 281, People versus Watts.
Your Honor, I believe on this one, my opponent did not request argument. I'm here, so I'll answer any questions that the court may have. Otherwise, I'll rest.
No questions, counsel. Thank you. Case 282, People versus Haynes.
Good morning.
Counsel.
Good morning. May it please the court. My name is Braden Gilman, and I represent defendant appellant Richard Haynes. Before this court is a number of trial issues. For the sake of argument, I might address points 1, 2, and 4 of our brief. Richard Haynes' guilt was not proven beyond a reasonable doubt when viewing the circumstantial nature of the case. Bolstered by misconduct and ineffectiveness, the solely circumstantial evidence presented resulted in Mr. Haynes' wrongful conviction.
Counsel, let me ask you a question. It seems if you go through the record in this case, you have some pretty compelling evidence. The victim's blood, is it not found in the defendant's bathroom or sink? It's also found on his bike, which is, his property. That seems pretty strong evidence, right? They tested the blood. There's no dispute that it is the victim's blood.
Well, with regard to the bathroom sink and the left handle of the bicycle, they were both in a group residence that Mr. Haynes resided at. So the bathroom was a shared bathroom that a number of his co-residents, including parolees, had access to.
But not the victim.
No, Mr. Haynes' residence.
Yeah, well, what I'm saying is the victim's blood was found in that residence.
Yes.
It's not like the victim was living in that residence and shared that bathroom.
Yes, but there were three other contributing DNA sources within that sink, and on the left handle of the bicycle, there was another unidentified contributor. And following the initial investigation by the police, they left the scene with the apartment door off the hinges, and there were a number of items that were taken from the complainant's apartment, including things that likely had DNA evidence.
So this is an argument that the investigation was botched in some fashion?
Yes, Your Honor.
Wasn't there also evidence, was it mobile phone evidence that the defendant had just prior to the fight up in the apartment, the second-story apartment, indicated to the victim that he was here, I'm here, meaning that he was in front of the apartment or at the apartment. That puts him right at the location just prior to the murder, right?
Yes, Your Honor, but mere presence is not enough to convict.
Yeah, but that's why we started this off with the argument about the blood being found where it was found. So it isn't just mere presence, is it? Let me ask you this. There are some other issues, though. In this particular case, I think we don't often get a situation where we have 4 eyewitnesses who are watching the person who's committed the murder, presumably, leave the apartment, and they know him and know the defendant, and none of them identify that person as the defendant in terms of body size and hair length and that kind of thing, correct?
That is true, Your Honor. And with regards to the physical presence within the apartment, that's why we talk about the mere presence. The physical presence, there was no DNA evidence or fingerprint evidence recovered from inside the apartment that tied Mr. Haynes to being in the apartment.
And this was a pretty bloody scene in that apartment, right?
Yes, Your Honor.
I mean, this murder resulted in blood on the ceilings and blood on the walls and furniture and all, quite a bit, right?
Yes, Batavia police say it's one of the goriest scenes in the history of the
How
city.
do you account for the hat that is located, the defendant's hat is located underneath the window where the defendant, the person that committed the crime escaped from the apartment? Underneath that window is the defendant's hat. How do you account for that?
Well, with regards to the scene and being a bloody scene, the hat that was recovered under the window had no blood evidence of the complainant on it. And there was also a DNA profile recovered within the hat that had someone else who was unidentified in the hat. And then with regards to the eyewitness testimony of people who saw him jump out the window, whoever the person was, they stated to be a white man, approximately 6 foot to 6'1", who is stocky or muscular. And as you state, he was either bald or had short black hair. And my client is a 5'9" Asian American man who's bald and doesn't really fit the description of what the eyewitnesses state. And when asked directly on cross, they say that this was not Mr. Haynes.
Yet the jury heard all this evidence, waited, and judged credibility of the witnesses, and came to a conclusion.
Yes.
And you're asking us to sit as a 13th juror in this case, weigh the evidence, and find it's not beyond a reasonable doubt.
Yes, yes, Your Honor. And with regards to it, one piece of evidence that was not presented to the jury, and we state this is because of ineffectiveness, was that there was a third-party individuals, 2 people that were planning to burglarize the apartment within the weeks and days leading up to the murder. And it was not presented that two eyewitnesses, one positively identified one of those planned burglars as jumping out the window, and another person identified the planned burglar as being at the scene or near the scene at the time of the murder. And that wasn't presented by defense counsel, and we're not really sure why. But so there is this way, kind of all of the evidence coming together in the totality. We believe it points not towards guilt beyond a reasonable doubt. Unless there are any other questions, we rest.
Thank you, counsel.
Thank you.
Good morning. May it please the court, Will Zickel for the people. With respect to the weight of the evidence arguments that are made, Justice Whalen, you certainly pointed out the fact that all of these things were presented to the jury, both positive for the people and positive for the defendant. Certainly, there were discrepancies in the description of the perpetrator as he fell from the second-story window, got up, and ran away. And defense counsel, and of course this relates to the ineffective assistance argument, defense counsel made great headway with those discrepancies in his argument. Perhaps not the ultimate result. But
certainly it was referred to and time was spent on it, is your point. Yeah.
Yes, he used it to his and his client's advantage at this trial. And that was, I submit, the best possible defense that could have been presented in this case. The third-party culpability argument, which was abandoned, as defendant puts it, although it was unexplained on the record why it was not pursued, it's not inexplicable. It can be explained in a number of ways. Maybe defense counsel went and spoke with his third-party culpability witnesses again after he made his presentation to the court and didn't quite like the way that they were coming across.
This would be all outside the record and not appropriate on the appeal.
But it's the defendant has to demonstrate that there was some lack of tactical basis for what counsel did, and
it could have been a matter of strategy not to call them.
There are a number of possibilities that could explain the failure to explore that defense, especially in the face of the evidence as presented, where the defense counsel had a very good defense that was essentially put in his lap, and that is the variances in the identification of the person who fell out of the window.
Counsel, my recollection of the record is that there were credibility issues with regard to all of the eyewitnesses to the alleged eyewitnesses to the crime. Is that correct?
Yes, certainly there were. One in particular who had ongoing communication with the defendant while he was in the jail and made statements such as, "Don't worry, I've got your back," which I think the prosecutor properly brought before the court during his summation. It is perfectly allowable for a prosecutor to point out circumstances by which a jury could conclude that a witness had a reason to make something up or tailor testimony.
And for each one of those witnesses who said that he wasn't the perpetrator, they all had credibility issues explored during the trial. Is that correct?
Yes. Oh, yes, they certainly did, including one witness's initial statement at the time when she was first spoken to by police officers, where she said the person who fell out of the window, the perpetrator, was bald-headed. And later on, she changed that story to say that he had short-cropped dark hair.
Any further, counsel?
No, thank you.
Thank you. Case 283, People versus Giles.
Morning, Your Honor.
Morning, Counsel.
This is Mark Phil Rothschild on behalf of Mr. Giles. The people in this case failed to establish the requisite element of the value of the property being above $3,000.
And you talked to primarily the $750 roughly in cash that's left on the dining room table in an envelope that your argument is wasn't really ever tied to the defendant.
That's only one part of it, Your Honor.
Go ahead.
That's because they're...
But if you're right on that, though,
Yeah.
does the dollar amount drop to a level that you need it to drop?
Yes, because the total they alleged in all was, I think, $3,385.60.
And our threshold is 3,000?
Yeah, 3,000. So
Yeah.
they're 400 and whatever. I'm not great at
So if
math.
you win on that, you win on the argument relative to the
Yeah, sure.
degree.
But it's much more than that, because there's two items in particular that made up the bulk of this, which was the iPad and the MacBook, the Apple MacBook. I think that made up, pardon me, I think that constituted about $2,300 of the value. I apologize. Now, the market value is the price of the item reduced for any depreciation or change.
I'm sorry, say that again.
I'm sorry.
Counsel, it was a
I'm
little quick
speaking.
and I'm not catching it. Yeah.
I'm speaking way too fast.
That's all right.
The market value is the price of the item reduced for any depreciation or change in its condition which affected the value at the time of the crime. It's not just the purchase price. Lay witness, rough estimate, and the original purchase price by themselves simply are insufficient as a matter of law. The proof of original cost without substantive testimony as to the condition of the item at the time of the crime is simply insufficient. Otherwise, the jury simply has to speculate and not make a logical inference as to what the value is. The original cost may suffice where it far exceeds the statutory threshold and there's no risk of rapid depreciation. That's just not the case here, because first of all, it's only less than $400 difference. And secondly, the iPad and MacBook have potential for great depreciation. I know that the people alleged in this case, well, there's no proof that there's any type of secondary market. Well, first of all, I think this court's case in Moncloven belies that, because there, I think that was a case from 2000, from the aughts, where they said a computer purchased in 2004 for $2,000 was simply insufficient as a matter of law to establish that 3 years later it was worth more than $1,000. And secondly, I think it's also belied by fact, if you take out your computers and you did a 2-minute Google search and you punch in MacBook in 2016, I think you'd probably find multiple places to buy them. I bought iPads before myself. Apple itself sells 2016 MacBooks for reduced prices. So there is that ready market. And we would submit that there was just insufficient proof that people failed to meet their burden as a matter of law. This was preserved by multiple motions to dismiss, and we would ask that this court reverse that conviction. Thank you.
Thank you, Counsel.
Your Honors, with respect to the valuation here, I would obviously take a different stance than an opposing counsel. I don't think that the laptop and the iPad here are so readily valuable or purchasable on the secondary market in a 3-year-old used state or however old the items were, such that we can sort of easily discern what the replacement or market value would be. I would draw a sharp distinction, I think, from these sort of personal consumer electronic devices compared to a car. There's lots of cases about valuation of cars. That's a lot more standard. There are cases about jewelry. Those consist of precious metals or stones. There's a ready market for that, even from scrap value, so to speak. The victims here are not in a position to simply replace the items with an identical one that they can easily purchase. It just doesn't exist. So to that end, I think the purchase price, which was substantiated by the receipts that were provided by the homeowners, I think that's a fair way to value these particular items. With respect to the cash, the $700, $750, depending on which witness we go with, I will have to admit that there is no direct evidence that showed the defendant in possession of that money. However, he possessed every single other item that was stolen, and those items, those larger physical items are obviously much more easily discoverable in the basement, as it were. The small packet of bills essentially.
The cash was in a bank envelope, right?
It was, which was left at the
Which was left
complainant's house.
At the
yes.
complainant's house, right.
Um,
So the envelope, the cash, none of that was found in the possession of the defendant?
Correct. I think it's obviously circumstantial, the case entirely with respect to the cash, but it was obviously right next to the laptop and the iPad on the kitchen table when the complainants went to bed. And it seems unreasonable to infer that the money went somewhere else during the course of the night when all of this other evidence was found in the defendant's basement. So on those points, I'd rest.
Thank you, counsel. Case 286, Verdugo versus Fox Building Group, Inc.
Good morning, Your Honors. Sean
Good
Cooney.
morning. If you hold on one second, Mr. Cooney, we've got one person appearing by video and Mr. Katz, and he's here. So very good. Proceed.
Thank you, Your Honor. This case involves two separate and distinct violations or failures for which the plaintiff cannot be the sole proximate cause. Of course, the Court of Appeals, it says once you have a violation of the labor law, it cannot occupy the same ground as sole proximate cause. It would be conceptually illogical to do so. In this case, the failures are initially the failure to secure the truss at the time the cable was detached. Number two, the failure to safely remove the rigging from the loaded truss and prevent the truss from falling. The third failure, admittedly, could be attributed to the plaintiff, and that would be his positioning, where he was tied off or not tied off to. But no matter where the plaintiff stood, no matter the reason he tied off, no matter whether there's a question of fact about that or not, we don't get there because of the first two violations. The most specific part of the record I want to point to is the officer of the plaintiff's employer, Pat Dwyer, is at the top receiving the truss. He is the individual responsible.
Let me just interrupt you, Mr. Cooney. He's receiving not a truss. Weren't they coming up jointly? Weren't two coming up at a time, or am I misreading the record?
You are reading the record correct, Your Honor. Mr. Dwyer does say he wasn't sure if it was one or two, and I think that would probably amount to an immaterial discrepancy in the record for both sides.
But you're not claiming that bringing up two at one time was improper?
Not for the purpose of this motion. I think it is, and if there was a question of fact and liability, there are a lot of other theories about that. That's not the reason I'm entitled to summary judgment, though.
Weren't they doing this all day long from 9 to 3 o'clock? And as far as whether or not the plaintiff had tied off properly or secured his lanyard properly to a secured truss, were they doing that all day long?
All day long. They did a number of trusts, and I think many of them described it one after the other, and sometimes two at a time.
And I think your client was instructed on how to use the truss, was familiar with the truss and the lanyard, and apparently had a history of utilizing these.
He's an experienced framer, and I think when we get to whether or not it's his valid reason for disconnecting is a question of fact, or can be decided as a matter of law.
Whether he disconnected or he connected to an unsecured.
Exactly, either one.
Well, is there a question that he connected to an unsecured truss?
Yes. He may have.
Or is the question is that he didn't secure himself at all?
There's a discrepancy in the record of whether he was secured.
Well, even if he secured himself to an unsecured truss or didn't secure himself at all, isn't that a sole proximate cause of it?
If there's no other violation of the labor law or a failure for which the plaintiff cannot be the sole proximate cause, Pat Dwyer was asked on the record, tell us what happened. He didn't say Mr. Verdugo didn't tie off. He said the cable came up. The cable came up, the end of the loop bumped the top cord of the truss, lifted it slightly, At that moment, the truss lifted up and shifted toward Ross Moores, another worker up there. Then the truss slid down on Joel's end, and Joel was on top of the truss and down to the ground where it hit the concrete. That's the person who
So
received.
he was secured then to an unsecured trust.
He wouldn't have fallen if he was tied off. He might have
Right.
fallen and been caught. There's no doubt about that. The physics of the record cannot refute that. There is a discrepancy over whether he was tied to a secure trust based on other parts of Mr. Dwyer's testimony. But what is
So let me just ask you another question on the facts. So when you say that this cable bumped, does the record establish that that happened before there was kind of the okay sign given to raise the trusses?
There's a dispute. The plaintiff says that Mr. Dwyer gave the sign to raise it. Mr. Dwyer says the plaintiff gave the sign to raise it. The bumping, Your Honor, it catches what Mr. Dwyer calls the core, the top structural member of the truss.
But so when does the bumping happen in relation to the giving the okay sign?
Afterwards, because they made a determination to raise the cable. It's not the timing of the determination to raise it, which could be the plaintiff, or could be the officer of the company who's there guiding it. The failure is not the timing. The failure is that the hoist, the cable attached to the crane, is not properly operated so that it removes itself from an elevated load at 14 feet without inadvertently striking it, lifting it, and dislodging it. So whether the plaintiff said, this is the signal to raise it, or Mr. Dwyer did that, the failure is the enumerated safety device. The plaintiff is not the operator. He's not the person guiding it up. No one says that it's his responsibility. Pat Dwyer admits that it's his. That's the failure. It's no different if a crane swung and inadvertently struck a worker and knocked him off the roof. And if that worker's not tied off, he has nothing to do, my client has nothing to do with the operation of that cable that has to safely remove a structural member of a building without inadvertently causing it to fall and hit someone, pull another worker down, or in this case, result in the fall of a worker who probably should have been tied to a different place or at all. But that's why sole proximate cause has the word sole, because he has to be the only cause. And he is not the cause, Mr. Verdugo is not the cause of the failure to operate that crane cable.
I'm assuming your opponents are going to say, well, if he had been tied off, even the cable hitting him wouldn't matter because he wouldn't have fallen, because he would have been secured.
They say that. In fact, I looked closely in the record. And
one of the reasons I was asking about the timing of these events.
And I think the timing it's important for the sense of what made it go up. It's not important for what causes the truss to become dislodged. Because if no matter who said the timing, if the cable is properly operated by Mr. Dwyer and the operator of the crane up without striking the truss, the plaintiff could be tied off, not tied off, any other circumstances, no one falls, no truss falls. If there was a worker below that was not wearing a hard hat and got hit by that truss, that worker would be entitled to 240. The plaintiff up on top, even if he is improperly tied off, which obviously the record is full of that proof, even if that's true, it's not the only cause. There is this other event that happens. In a crane, there's a case Fitzsimmons. A crane is an enumerated safety device. It has to be operated properly. When it's not operated properly and it strikes a load and causes it to fall, that's a foreseeable gravity-related event resulting from the failure to operate an enumerated device. Once that happens, the Court of Appeals in Blake has said it's conceptually impossible for that to occupy the same ground as sole proximate cause. Sole is only. And when you look at the briefing and when counsel stands up here, and every time the issue of that failure of the crane cable comes up, the only thing they can say to attempt to raise a question of fact is, yeah, but he wasn't tied off properly. That does not raise a question of fact about Mr. Dwyer's admitted testimony that the cable cord he was responsible for guiding out caused the truss to shift and fall.
Let's talk about the lanyard for a second. Okay, so he had a single rope that he could tie off with. So correct me if I'm wrong, but there was numerous times during the correct procedure that was happening, that the plaintiff wouldn't be tied off because he had to untie himself, be untied, and then attach himself to the next one. So even built into this procedure, there are times that plaintiff, just wouldn't be tied off, and it wouldn't be because he was doing something improper. But that's what the system was, a single lanyard, and you had to untie and retie, leaving you unprotected at certain amounts of time during the process, correct?
Absolutely, and I think that is similar to Justice Montour's question about the two trusses, and when I said that's relevant to whether there's a question of fact about sole proximate cause. The Fourth Department in the decision KIP, there's a dissent in that case about whether or not the ladder was properly placed for the valid reason of where the worker had to work. In this case, Mr. Verdugo, at the time of his deposition, he's gone on to become a union framer. He's a non-union at the time. I'm pretty sure he's a union framer now. He is well-trained. He is utilizing a very complicated, inherently without fall protection, occasionally setup over and over again all day without incident. His reason under the law has to be a no good reason. And I don't think you can tell someone who has all of this training and all this experience that defendants point out over and over again, who made his determination where two trusses are brought off and a worker has to follow this complicated scenario to get one truss in, secure it, push the other one, unhook, reconnect, brace that one. No one could do that without occasionally
Wasn't
being
there a question
untied.
during the depositions that your client was asked, so first you tied yourself to the unsecured trust, and then you were going to secure the trust with nails? And his answer was yes, because we're thinking that the cable will maintain and support the trust before we put it in that position and mount it. So he was aware of the fact that it was, according to this questioning, he was aware of the fact that it was unsecured at the time he secured his lanyard to that.
He says we were under the impression that the cable was still connected to it. So this is to Justice Bannister's point. He thinks at that time the crane cable is still holding that.
He's still attaching himself to an unsecured trust.
Because he thinks it's still attached to the cable. That's that testimony. As I said to Justice Paradotto's question, you can't ignore the physical evidence. He fell. If he was tied off to a secured trust, he would be there hanging. I mean, I think there's no reading of the record.
So his testimony, they thought it was still attached to the cable. He thought it was relatively secure to attach to that truss.
Correct.
Because of that.
Correct.
And you would say that that doesn't fall under the category for no good reason?
Certainly not as a matter of law.
Right.
And I think that's really the key when you get to sole proximate cause, is we're asking to make a factual determination about this process that has multiple time periods where you're unclipped by definition, well-trained, well-experienced people that are doing it over and over again without incident. He has a number of reasons. The two trusses, he says, are difficult. They deny that, which is fine, but not for the purposes of a summary judgment finding. He says that the speed is an issue. He says that his reach is an issue. No, they refute all of these things. I'm not saying that they haven't raised a question of fact about sole proximate cause, if we even get there because of the initial violation, of course. I'm just saying it can't be sole proximate cause as a matter of law, because it's no good reason. And I don't think on this record that anyone can say as a matter of law that the plaintiff's determination was not good or invalid as a matter of law. But more importantly, if you ignore the operation of the crane in the first instance, this would allow a situation where a crane could collapse, knock off an entire crew of workers off a roof. If they're not tied off, that's not 240. That's not the law. The law is if you don't operate an enumerated safety device and it causes harm as a result of a gravity-related preventable incident, unless the plaintiff's the only reason for that, you get 240. It's a very, very high burden, and Mr. Vertigo has nothing to do with that crane cable's requirement to be safely removed from the load, past the trusses without dislodging them and knocking him down. Thank you.
Thank you, counsel.
Good morning, Your Honors. May it please the Court. Stephen V. DiBraccio of Burke, Scala, Merrill, and Hurd for Defendant Hinsdale. let's cut to the chase. The 4 elements of sole proximate cause. This is a straightforward case of sole proximate cause. Mr. Cooney and plaintiff have not disputed that there were adequate safety devices available, the harness and lanyard, and that he knew it was available and was expected to use them. He was instructed daily on the proper use of a harness and lanyard to a secured truss. It was pointed out, I believe, by Justice Montour, the Dwyers would go around looking to make sure people were tied off, and if they were not, they would be corrected. Plaintiff admits, and Mr. Cooney notes, the plaintiff is a very experienced framer, and for no good reason, he failed to tie himself up.
Counsel, let me ask you this. Is it your position that at all times while the plaintiff was working up there, he would have been and should have been securely tied off to a fixed, what do we call them?
Trusses.
Yeah. Or did he have to, during the operation of his work, detach from the truss to reattach to the next secured truss?
The answer is about in between those two hypotheticals.
Explain it to me.
Absolutely. He certainly had to change his position between cable ups when the trusses were coming, but not after the OK signal was given. So when the OK signal was given, the truss is coming, he is to be secured. He certainly has to move his trusses as the work goes along, but I would not call that while he is working. That's while he's waiting for the next truss to come up.
So really, it seems to me that the main question here is whether he chose for no good reason not to attach himself to a secured truss. The proof is that he attached himself to a truss that was unsecured, but it was still attached to the cable. So he thought that would be safe and stable. Do you get past the chose for no good reason not to do so with that proof in the record?
Does defendants get past that?
Yes.
Yes, for 3 reasons. First, as Mr. Cooney admits, he's an experienced framer. It is illogical for him with his experience to say he did not know that he was supposed to secure himself to a secured truss.
Well, I don't think he says that. I think he does say he knew he was supposed to secure himself to a secured truss. But he says that he didn't for this reason, because he thought it would still be safe at that moment.
That is belied by the Dwyer's deposition testimony of their instruction to him as to why it was unsafe to secure himself to an unsecured truss. He received instruction on this on the day of the accident and just prior to the accident when he was corrected for doing it the way he did it.
I don't recall there being anything in the record that says that the other 2 employees who were working with the plaintiff also took the tactic of securing themselves to an unsecured truss with the belief that the cable was still attached. I don't recall seeing that.
You are absolutely correct, and that is very important for this reason. Mr. Cooney talks about the crane. The only way a plaintiff can demonstrate a 240 violation is by showing that the violation caused his injuries. He can't get past the causation element because the 2 other workers who tied themselves off correctly were not injured. Irrespective of whatever happened with the crane, they were not injured. So the only sole proximate cause of this was plaintiff's misuse of the provided safety device, the lanyard. If I could talk briefly, Justice Paradato asked about no good reason. Let's talk about that. Plaintiff gave 2 reasons in his deposition testimony why he did not secure himself, other than what we just talked about, he thought he was secured to the cable. It was faster, and he didn't think he had enough slack. It is faster is not a valid reason to violate safety protocols at work and to violate the training that he was given. And besides the common sense element of that,
I can see that argument. If the only reason was it was faster, that might not fall under the category, or that might fall under the category of no good reason. When you couple it with, he actually thought that he was securing it because the cable was still attached and secured and it was safe, it seems we might be getting closer to for a good reason.
I disagree for this reason. I would agree with that proposition if he were not specifically instructed that his thought was wrong. He was told by the Dwyers, you are to secure to a secured truss. And the way he performed his work was corrected on prior occasions prior to this accident.
Don't we run the risk, though, if we follow that argument too closely, don't we run the risk of general contractors, for example, handing out a safety brochure before a job site that has all of the instruction, hand it to the employees and say, there you go, those are all the instructions, and therefore they gave them the instructions, they didn't follow the instructions, they're recalcitrant workers. And if we were to follow that train of thought to its inevitable conclusion, I think we wouldn't be finding ourselves where we are in the state of the law today.
I disagree with that because of the Bianca-Nato case from the Court of Appeals. There, the Court of Appeals found there were tribal issues of fact because there was a standing order to do the work a certain way, but the supervisor didn't give instructions and actually suggested, yeah, you can do it another way. That is an example where just giving a safety manual is not sufficient to establish sole proximate cause. However, in this case, we have not just the safety manual, but the daily instructions and the corrections that occurred prior to the accident.
Tell me about the corrections, the prior corrections.
Paul and Pat Dwyer testified that they would continuously watch the employees to make sure they were secured to a secured truss, and plaintiff was one of them. They testified there were occasions that he was not tied off properly to a secured truss. He was tied off, I believe, to an unsecured truss, and they told him, you need to correct that, and they corrected him. And he then did it correctly in accordance with their policy up until the time of the accident.
Any further, counsel?
Yes. I just want to...
Be mindful of your time.
I'm sorry?
Just be mindful of your time.
Certainly. I just want to note 2 points. This distinction between failure to follow instructions and misuse of a safety device. Mr. Cooney's rule attempts to swallow the rule of sole proximate cause, to say, well, it was just a failure to follow a safety device, follow a safety instruction. I concede that if that was all there was, an instruction to not step in a hole, for example, that would be insufficient. He was given a working lanyard and harness that has been uncontradicted by expert or anyone else's testimony, including plaintiff. And I should point out also that plaintiff admitted that the device was proper. I want to just point out Justice Whalen's dissent in Kipp. Justice Whalen discussed that in Kipp, the defendants failed to establish the plaintiff improperly placed the ladder for no good reason. And the conclusion there was the plaintiff argued that I was worried about damaging the windows. That is a different case entirely. This is an even stronger case than Kipp because, again, his argument was it was faster and I had no slack. On the slack point, and I'll finish with this, that is contradicted both by the fact that his two co-workers had the same amount of slack and performed the job without issue, and by simple math, the truss was 2 feet and he had 4 feet of slack. So by math, he had enough slack to perform his job. Thank you for the questions.
Thank you, counsel.
Thank you.
Good morning, Your
Mr.
Honor.
Katz?
Yes, Your Honor.
Are you proceeding next?
Yes, sir. My name is David Katz from Smith, Sovic, Kendrick, and Sugnet. We represent the defendant respondent, Fox Building Group. Mr. DiBraccio did a great job presenting our arguments. I did just want to highlight one or two things, and then I will otherwise rest on the brief and his arguments. The plaintiff here is, first off, I'd like to just note that this is much more than a safety manual. As he noted, there's daily safety meetings when they're sending people up into the air. There's visual confirmation throughout the day. there's a harness. So I understand the concern about the safety manual alone, as Justice Whalen was pointing out. This is just not one of those cases. Certainly, those are higher hills to climb because it's merely a safety manual. Here, there's much more. They built P. Dwyer actually built on that manual and instilled that manual and its values in its employees. So I think that policy concern in this case doesn't bear out, although it may in others. I would also note that this is not a case where the plaintiff is talking about transitioning and the lanyard fails him, right? There was some discussion of the one harness, one lanyard. Sometimes on jobs, there's two. But the plaintiff's complaint here is not that he was in the midst of transitioning and therefore was permissibly untied to the extent that he was just in the process of getting to another another beam. He was already reattached. It's his choice to reattach to something that is improper that is the sole proximate cause. So this is not one of those cases where he just happens to be in that moment of uncoupling to recouple. And I do think that is an important distinction here, because I do understand how in a different set of facts, that type of argument could be persuasive or raise a question of fact. But his testimony here and his theory here is that he had already reattached. So the mere fact that he would have to transition at some point is immaterial to the question as he has phrased it and as he has presented the evidence. The only other point I would like to just briefly touch on, Your Honors, is this discussion of the hoist as safety device. The operative device here is the harness and lanyard. The crane, and as we talked about in the brief, there are crane cases and crane failure cases. Those are completely different from this case for two reasons. One, many of them are falling object cases, which raise different concerns. The second is the harness and lanyard do actually protect against what has occurred here. And the reason we know that is that the two other people were in fact protected. So the harness and lanyard are an effective form of safety device as to the crane, as it would be presented here, insofar as it would stop somebody, if they were properly secured behind them, as they should have been, from having an issue in the event that that extremely rare event occurred. And that was the testimony that it's an extremely rare event. And for those reasons, Your Honors, if there's no other questions for me, I will rest on the prior argument.
Thank you, Mr. Katz.
Thank you.
Good morning. May it please the court, my name is Christopher Getty. I represent CBD Construction. There's not a whole lot. There was a few questions that were brought up by the justices, and I think these have all been answered, and especially the one Justice Bannister raised about, isn't there this process of you unhooking during the day? Absolutely. But in this case, at the time of this event, he should have been already attached to a secure truss, and he doesn't move and do anything until the trusses that are up there are fully secured. Then he unharnesses and latches back in to a now secured truss, and that's the difference. Okay, so he did this process knowing that he did it wrong. He did the process anyway.
Are you saying he unhooked himself too early?
Yes. We don't have the arguments being made that it has something to do with the crane and this moving the truss and that sort of thing, but you don't get there because he's supposed to be hooked on, secured to the trusses behind him that he's already secured, right? So you have two trusses, they go down, you secure one, you secure the other, you move, then you unhook from the trusses that are behind, you then hook into the trusses that are now secured in front of you. You then move on to the next set of trusses. He didn't do that. The truss is up there, he unhooks from the secured truss and walks over, and the light most favorable to him says he's securing himself to this unsecured truss, meaning it's not, the crane part is irrelevant, secured, nailing it in, putting the bracing in. And he ends up riding this truss to the ground because he wasn't secured to the trusses behind him. He's trying to secure himself to something that's not nailed down and braced yet.
Is the crane part irrelevant when in the plaintiff's mind, the crane was still holding the truss in place, giving him that time to move over and secure the truss?
Yes, because again, you don't get to, whether this thing gets knocked down or whatever happens to it, you don't get there because he's supposed to be back and secured to this other truss at the time. And then he moves up and he starts securing the truss in front of him. He ends up riding this one down because he's on it, trying to secure himself to it, or he did secure himself to it, because there's testimony that says he wasn't secured to anything. He literally took this off, and he shouldn't be having that thing off until the trusses are in place, secured, and then he can move forward, and he can do that.
And I don't think there doesn't seem to be a lot of dispute about that the mechanics of that. The question, I think, that we're confronted with, at least one of the questions, has to do with whether or not when he did that, admittedly in violation of what he had been instructed, whether he did that for no good reason, or was it a good enough reason that he felt, with respect to the movement of the job, that was secure and it was safe for him to do that. It may clearly not have been what the company had directed him. The question is it a good enough reason, or was he just being reckless up there? And reckless is the wrong word, because that's a term of art.
I don't, thinking that it's secured to a crane, which is to the hoist that's being removed. How would a person think that was a good idea? You have this thing dangling down that's being unhooked.
And that, we understand, that's your argument. Your argument is his thinking was skewed, it was wrong on this, and so it falls under the category, he did this for no good reason.
It's no good reason. Yeah. There's no, because again, no matter what, this thing could slide. I mean, they're pushing these things into place. It's not like they're being set. They're putting two trusses on there, and they're next to each other. You're pushing another, you're taking one, you're securing one, then you're pushing the other one into place. At any time, it might be that for some reason, it might fall to the ground, right? Mm-hmm. You're going to depend on whether or not the hoist is attached. No, you're not going to be standing on that thing for any reason until it is secured and braced in place, and then you move forward. And I think no, there's no good reason. There is no good reason. And I think that's borne out by the record. I'm not just saying this. I think it's borne out by the testimony of multiple parties or multiple witnesses.
I think that's clearly been defined as the issue before us.
Yes. The only other, let me just see if there was a couple of questions. Well, the crane knocking people off, I think it falls under the same thing. It's true. Those cases are distinguishable, but the idea of a crane knocking people off, again, if he's not near and he's not standing on and riding on an unsecured truss, whether it gets knocked off is irrelevant, because he's not supposed to be there, because he's supposed to be back here hooked into these other trusses. So again, you end up in the same spot, I believe. The only thing I would say, and the case has been cited for, and that was with regard to, in the event that the court does, and again, not conceding the point at all, I believe the Bianca-NATO case also provides the court with, in that case, the facts are actually far less strong than here. And this is where and again, it was related. I don't want to go through the whole thing, but it's the general contractor had a standing order that workers were not permitted to enter the building, but there was no evidence to suggest where the plaintiff's employer were advised that there was this standing order, okay? And other workers performed similar maneuvers in the past. In that case, the Court of Appeals found there was a question of fact on the sole proximate cause issue. Our facts are stronger in this case in that you don't have, as Justice Whalen indicated, you're handed a piece of paper, and by the way, here's the rules, go to the trusses. You had multiple inputs to these individuals about what you were supposed to do and the right way you were supposed to do it. And in this situation, there was a question of fact. So if there was a question of fact here, if it is shown that there's multiple layers of instruction given to him, I don't know, I think that first you should find that there was sole proximate cause. But if not, there's at least a question of fact on the sole proximate cause issue. And instead of granting absolute liability against the defendant. So I wanted to point that out, that not that we're conceding the point at all, but those facts are lighter than ours. Ours is a better case. The only other thing I wanted to say about CNY is that, just in case, again, if the court is exploring this idea of reversing, only that CNY, although there was not a direct, they would not fall into the labor law. They should not be completely dismissed from the case because of the cross-claims that all of the other remaining defendants would have. And I just wanted to point that out, that if that was the case, if CNY Boom Truck, if there was a reversal, that they shouldn't be just kicked out because of the procedural stance that the plaintiff took, which is not clear to me, is they didn't appeal anything other than negligence or anything else. We would still have the cross-claims, including negligence, that can be maintained against a vendor like that.
Thank you, Counsel.
I just want to point out. Thank you.
Morning. May it please the court. Megan Brown on behalf of CNY Boom Truck. I'll address my points in reverse order and start with sole proximate cause just very briefly, since it's been ably covered here by all my colleagues. Just wanted to mention two things. This issue of, or the question of whether it was for no good reason that the plaintiff thought he was okay on the unsecured trust because he thought it was still attached to the cable. That is addressed directly by our expert, Mr. Merrill, and his opinion starts on, his report or affidavit starts on page 563 of the record, and he addresses exactly why that was no good reason, because that in and of itself is a violation of, I believe, OSHA regulations or other statutes. So it was no good reason to attach thinking it was still hooked to the cable, and our expert explains why, and that's never been rebutted by the plaintiff or any other parties. So I would address, adding to what's been said before, that further supports that it was no good reason for being attached to the unsecured trust. Also, this is sort of the first time I'm hearing that there's any issues with the operation of the crane. That's really not ever been an issue in this case, certainly wasn't addressed below. And I think I understand Mr. Cooney's argument to be that it was Mr. Dwyer who was responsible for guiding the cable up, but to the extent it's his position that it was some error on the part of the crane or the crane operator. I would note that the negligence claims are gone. There's no negligence by the crane operator. Those claims have been dismissed. That's not been appealed. And then also I would point out there is evidence in the record that the rigging was proper, and that's in the record at pages 575, 578, 1202. And there's testimony that the cable bumping the truss is not a mistake, right? You have a cable, it gets unhooked, the crane operator lifts it. It's something that is moving, and the possibility of it hitting a truss is something that is known by everyone in the industry. And the testimony that the cable bumping a truss is not a mistake is at page 1062 to 1063 in the record. So, that's exactly why you're tied off to a secure point, as our expert, Mr. Merrill, points out. In case the cable bumps the truss that's not secured, you're secured. So, that's all I'll say on the sole proximate cause argument. I think that's been addressed. But frankly, with respect to my client, CNY Boom, the court should affirm the summary judgment order without even reaching sole proximate cause, because CNY Boom is not a proper labor law defendant here. They had they weren't an agent of the owner or the contractor. This was not addressed in the plaintiff's brief. And in fact, in the plaintiff's opening brief, where they specifically mention how the owner and the general contractor are proper labor law defendants, and CNY Boom's name isn't even mentioned in that argument point. And I think it's obvious why. They're just not a proper labor law defendant here under 240.
Your colleague mentioned something about cross claims.
Well, the negligence
specifically
claims
asked us to keep you in.
Well, I disagree with my colleague on that point, and possibly that point only in this case, since we've obviously are on the same page with respect to sole proximate cause. The negligence claims have been dismissed as a matter of law. So there's no contract between CNY Boom and any party to this case whatsoever. There's just no basis to hold them in with the negligence claims having been dismissed, and the evidence is clear that they're just not a proper labor law defendant.
Thank you, Counsel.
Thank you.
Case 288, Di Pasquale versus Lim et al. Proceed, counsel.
Thank you, Your Honor. Good morning. My name is Samantha Riggi. We represent the plaintiffs. Your Honor, I'd like to address whether or not the defendants first established whether this document at issue, specifically the Harris-Clacker email, was in fact created in furtherance of quality assurance or requested by the committee. It is clear that where a party seeks to withhold relevant evidence, and I don't believe that any of the parties dispute that this document is both material and necessary, but where a party seeks to withhold relevant evidence from disclosure, the party must establish that the matter was reviewed by a quality assurance committee and that that document it seeks to withhold was generated in connection with it. We respectfully submit that while the defendants have established that the facts and circumstances of the plaintiff's care and treatment was reviewed by quality assurance, they have failed to make that showing as to how the email was created at the behest of the committee or in furtherance of it.
Counsel,
Yes, Your
my
Honor.
review of the record indicates that this email was generated before that quality review process had even begun.
That's correct, Your Honor.
Okay, so under that scenario, timing-wise, it's not part of the quality review function.
Yes, Your Honor. And we agree and respectfully point out.
Counsel, on that point,
Yes,
let me
sir.
ask you this. There does seem to be in the record an indication that even before the email was generated, that there was an investigation commenced, right? So maybe the committee had not been established. Maybe a date for the committee to meet hadn't been established. But if we're going to talk about process had begun, would you agree that when an investigator began work relative to a quality assurance issue, that the process had begun?
Your Honor, if I may, I disagree with the fact that I'm not sure that the process had begun at that point. If in fact this was a statement made by the defendant to trigger the QA process, or if in fact there was anonymous posting, I believe that the affidavits described a process by which Highland Hospital can initiate that process, the one being called an anonymous post through RL Solutions. Had those things happened, yes, Your Honor, I would agree that if the QA process had been underway and if Harris-Clacker had said that she knew the process was underway or that she thought it was her obligation to report an adverse event or that she had an understanding or anticipated the QA meeting, then yes, I believe that had Harris-Clacker submitted an affidavit clearing those things up, then we would be having a different conversation. However,
And your argument is it's their burden to do just that.
Your Honor, I do. And I think that the absence of anything from Dr. Harris-Clacker is quite telling. And I also, if I may, point Your Honor to page 15 of the defendant's brief. And I think that this is really the crux of our argument because the defendants themselves concede in their brief that QA wasn't formed when the email was sent. They state that. They also, on page 302 of the record, acknowledge the gratuitous nature of the email. So again, we don't have something where the defendant, Dr. Harris-Clacker, indicated that she was, in fact, trying to trigger the QA process.
So I think further, it appears that the email was published to people that were, in addition to the members of the QA committee, to others.
That's correct, Your Honor. There were, in fact, a number of recipients to the email that were not part of the QA process. So again, I think that if this was something, or I submit to this court respectfully, that if this were something wherein Dr. Harris-Clacker just sent it to members of the QA committee, although the committee had not been formed, or at least somebody who is typically involved in QA, with the understanding that that would trigger the process or that she thought that this was going to be discussed because it was an adverse event, then yes.
But she certainly can't waive the confidentiality process on behalf of the committee. I mean, she's not a member of the committee, so So it's not that that would constitute a waiver.
Correct, Your Honor. And that is not our position with respect to Dr. Harris-Glocker's silence. Our position is rather that had she authored an affidavit explaining that that this email was sent because she thought that it was the proper way to trigger QA, then in fact that would have cleared up where we are here. But however, we don't have anything from her in that regard. And I think, again, the defendant's position in their response to papers that QA had not been, the committee had not been formed, I think is quite telling. I also, if I may, just point out that the defendants make a painstaking effort to analogize this case to Noel. But I don't even think we need to get to Noel, because this court in Noel was asked to adjudicate whether the exception applied. In other words, the threshold question at issue as to whether or not the document qualified as QA was not at issue there. I mean, I appreciate the defendants keep reiterating it, but it's just very different than what we have here. There is no evidence in this record that Dr. Harris-Glocker reported the care and treatment as an adverse event. There is no evidence that she sent the email pursuant to any QA protocol. And by the defendant's own admission, again, the committee was not even formed before she transmitted the email, and there is no evidence in the record that anyone from the QA committee contacted her and instructed her to send it. That is what this court decided in Noel. Very different facts. And certainly to the extent that the court has any questions, I'm happy to answer them, but I will otherwise rest on our papers.
Thank you, counsel.
Thank you, Your Honor.
May it please the court, Amanda Burns for defendant respondents, Highland Hospital and the University of Rochester. I want to address the 3 points that appellant's counsel made. Starting with the issue of whether or not the QA committee had been formed is not the relevant inquiry here as to whether the QA privilege is triggered. While appellant's counsel said that Noel is not instructive here, Noel is particularly instructive on this point. In order to get to whether the party exception applied in Noel, the court necessarily had to decide that the privilege applied in the first instance. There, the court held that it did, and the statement at that point was something that was provided to a QA investigator. The same instance applies here. Dr. Harris-Glocker submitted an email to Cindy Becker, who is the chief operations officer at Highland Hospital, explaining the facts and circumstances of an event that clearly would have triggered a QA review.
So that, and there's no question that the QA review used the information that was sent.
Correct. Ms. Gamina's affidavit clearly walks through the fact that she was provided this information. In fact, she says she would have solicited this information from Dr. Harris-Glocker on her own, and it saved her a step in her investigation.
But the timing somehow seems to matter. I mean, the law out of our department in the Court of Appeals says that the information has to be generated in connection with the QA review function. That seems to actually be kind of a more narrow test than what the statute actually says, but that is the law of the Court of Appeals and of our department. You know, that the statute itself talks about records relating to the performance of the QA assurance review.
And Justice Peredato, in that vein, when you talk about the exact language of Education Law 6527, the language is precisely that, relating to the performance of a QA review.
But the Court of Appeals has said that it's got to be generated as part of the quality assurance function, and I think that's
and it was, and I think the issue here is the broad nature of the QA privilege is to allow hospitals to frankly and without fear of legal reprisal review events.
Well, Counsel, I might disagree with you that it's not a broad exception. I think it's a pretty narrow exception that you have to prove applies.
Yes, and so the issue here, the distinction is the timing of when Dr. Harris-Glocker submitted this. And it's our position that had she submitted it and it had triggered a QA review, which she did not know, it would be privileged. It would be part of that QA review. And a QA review has to start at some point. So to hold that the review needs to be ongoing and requested to fall under the protection ignores the fact that then any provider's initial report of an instance in which they try to provide their frank and objective feedback as to what happened would not be protected under the privilege.
And it's clearly used as part of the process.
Correct. And in line with Noel, the reason that that statement was protected was that the hospital established that they had a QA process in place to review such events. The statement was received as part of that process, and that the QA investigator then reviewed, relied upon, and incorporated that statement into the investigation. That was then ultimately submitted to a QA committee.
I think we could probably agree the letter was unsolicited, right? I mean, we definitely agree that. Nobody asked her for that letter.
No, but they would have as part of the review. I mean, she was
at some later time. And so the letter wasn't in response to a QA committee's request for some kind of a summary.
But the problem there is if it was a QA committee request for that, it would fall into the party statement exception.
That's true.
Whereas if it is something that is in the investigatory process in advance, such as the statement that was provided by the defendant respiratory therapist in Noel, it falls under the protection. Because if a provider who's named defendant in the case, as Dr. Harris-Glocker is requested to provide a statement by a QA committee, they have the knowledge that that is a party exception and it's subject to disclosure. Whereas in the investigatory phase, the purpose is to provide a frank explanation of what occurred so that the hospital can improve and not have it be used against them. And that's exactly what Dr. Harris-Glocker did in this circumstance.
Thank you, counsel. Case 291, AEY Enterprises versus LG Evans Construction.
Good morning, Your Honors. May it please the Court, my name is Andrew Burns. I'm here on behalf of my client, AEY Enterprises. The record before the Court shows that after being provided with confidential information regarding AEY, including confidential information regarding its employees, including specifically Michael Hill, AEY's Vice President of Operations and its number 2 employee, and also learning that Hill was interested in buying AEY, LG Evans ended up not purchasing AEY and then violated the non-recruit, non-hire provision in his agreement where he specifically promised he wouldn't recruit or hire any AEY employee.
Where in the record, counsel, can we find the evidence or what you rely upon to indicate that he, and we'll use the word, forget hire for the time being, recruited? That he recruited as opposed to people coming to him, and or does that not make a difference?
Well, you've got the hiring part anyway, so right. Recruiting and hiring. But the recruiting is, you have a conversation with a prospective employee. It's immaterial who contacted who first. That doesn't matter. Someone's coming to me or I'm going to them saying, let me tell you about LG Evans and why I want to hire you as an LG Evans employee. And here's what I'm going to pay you, and here's what your duties are going to be.
Isn't the idea, and correct me if I'm wrong, the idea of an agreement such as this is to allow for your client to market the property, the business, with an idea that he can reveal information that he wouldn't otherwise reveal to potential competitors, without fear of them using that information against him.
That's exactly right.
Right?
That's exactly
and
right.
That's what was trying to be accomplished here.
That's what was trying to be accomplished.
And it's sticking to just the recruiting portion of this, and I'm trying to understand your argument along those lines. You're saying that recruiting language, I envision recruiting to mean that you're not going to learn this information about my employees and then come in and start poaching my employees, which would I think would be kind of what might happen without a contract like this or an agreement like this. But it doesn't seem to me that I can find any real evidence here that there was an act of poaching, but rather employees going to, what was the name of the company? I'm sorry.
LG Evans.
LG Evans, yeah. Going to LG Evans affirmatively. In other words, there's no recruiting tells me that you're going to take that information. I'm not interested in the buy at this point, but now I've got information. I'm going to call your people up or email them or contact them and hope to bring them over. So because you've got key employees that are really going to help me, which would be completely, it seems to be contrary to the whole understanding of the agreement.
Well, there's evidence, we believe, in the record that shows that Hill went to a work site, talked to where 8 employees were, including Fody, talked to them about LG Evans. And there's evidence that Hill talked to Don Lewis, the chief estimator, told him that he was leaving for LG Evans. Again, whether,
I misunderstand this, but Hill was part of LG Evans, or was part of
Hill
Don's
was
group. It wasn't part of LG Evans until he joined LG Evans.
Right.
So Hill going there, at least before he joined LG Evans, are you saying, you're talking about...
So before he joined LG Evans, he told Don Lewis he was going to LG Evans.
Right.
So he let him know that.
But that's not LG Evans acting and recruiting, right?
At that time, Hill was going to go work for LG Evans. He had agreed to it.
He's not acting on behalf of LG Evans at that
Well, I think he probably is acting on LG Evans at that point of time. He's telling a co-worker.
Is there evidence in the record that demonstrates that LG Evans and Hill had conspired to get Hill there to go recruit on behalf of LG Evans? Because I don't see that.
Conspire is a big word.
Agreed.
Yeah, conspire is a big word.
Yeah, agreed.
What happened is these guys come to us. We tell them about the company. We give them information about our key employees. And there's no dispute that Hill was a number 2 guy. Don Lewis was a chief estimator, really the only estimator and the only foreman. And Fody was a foreman and an operator. They were all valuable employees. He would not have learned about any of them. It's different than the district court case that got dismissed, where there was something indicating that the company that ended up hiring the guy knew about this guy already. Jeff Swan didn't know these guys from Adam. He's provided all this information about him. Then he finds out that Hill's interested in buying the company either. Is there a conspiracy? I'm not saying if there was a conspiracy. I don't go that far. I don't think I need to prove any sort of conspiracy. The contract says you can't recruit, you can't hire. They definitely hired. We think they never would have recruited them, but setting recruiting aside, they never would have hired them unless they were, if they were not provided with this information, they wouldn't have hired them. And I don't think our guys would have known to go to LG Evans. But once it's known that this is a potential acquirer of the business, the number 2 guy goes to work for that business.
So very simple, you say, without this exchange of information, the hire never takes place.
That's exactly right.
On Hill, Foyt, and Lewis.
Right. You hire Hill, and now all of a sudden you got all the access about information about Lewis and Fody. That's correct. That's correct.
Anything further?
Well, with respect to the other claims, which we not move for summary judgment on, the other causes of action, those kind of got tossed away under the same reasoning of a lack of causation. But I don't think that reasoning stands. The brief addresses it briefly. For example, did they dispose of the confidential information correctly? That doesn't have anything to do with causation. Did they talk to employees when they shouldn't have? That doesn't go with confidential information. So those claims...
You're saying that so those claims kind of got swept up?
Those got swept up in this conclusion that because the 3 employees just decided they didn't want to work for AEY anymore, that breaks a causation, which I submit it does not. And then those other 6 claims got swept up. We didn't move for summary judgment because, frankly, there's questions of fact regarding those 6 claims, whatever there are, 5 or 6, whatever they are. Thank you, Your Honor.
Very good. Thank you, Counsel.
Good morning, Steve Sessler for LG Evans and Michael Hill. First of all,
with regard to this record, I would note that on pages 35 of the record and 37 of the record, those are the two confidentiality agreements, and there are two portions that I would like to just briefly read. They state, "We, being AEY, we are happy to share this information with you as long as you agree to keep it confidential as outlined below." The word "it" there, to my belief, is this package of information that was given to Hill and to Jeff Swan on behalf of LG Evans. And so it is in this context where it is my belief that a breach of this contract, a breach of this agreement would have to demonstrate that there is some sort of connection between the use of this information that was given during the acquisition negotiations by AEY to LG Evans and to Mr. Hill. That would be necessary to causally connect or to actually say that there's a breach of this particular contract. Because New York doesn't recognize these restrictive covenants standing alone. Those are contrary to the New York law as to what we're going to do by way of restricting.
But your opponent is claiming just because of the disclosure, that's how they found out about Mr. Hill, and they wouldn't have hired him but for that disclosure. What say you on that?
Right. Well, yes, Your Honor. So with regard to that, there are a couple of things. If you look at the time frame, you're going to see that defendant Hill, Michael Hill, was employed by AEY, and he was interested in purchasing AEY from its owner, and he went through and did his confidentiality agreement first and then made a determination that he wasn't going to purchase. And then subsequent to that, along came LG Evans, a subsequent suitor. But it was only after even LG Evans contacted AEY and said, "We're not interested in purchasing you all," that then, and only then, that Michael Hill, in that period of time, then started looking for other work and then reached out using LinkedIn to Jeff Swan at LG Evans.
Right, Hill denies that there was any connection there, that he was unhappy and looking for a new job or looking for a new position, and that it came about, even though it's a coincidence, it came about independently of any of that information that he learned.
Right, and if you think of it, how would Michael Hill even know that LG Evans, a subsequent suitor, was a subsequent suitor when he reached out? There's no evidence in this record that Michael Hill even knew that LG Evans was out there. With regard
that might, as your opponent in my questioning clarified, that might address the recruiting part. In other words,
right,
that maybe LG Evans didn't recruit Hill, that Hill found his way there through LinkedIn and the way people find jobs, whether it's Indeed or whatever it is.
Right.
All right, he finds his way there. But what about the hiring? Clearly, LG Evans knows Hill. He signed the agreement, and now Hill is soliciting employment at his company.
The record
Does the agreement cover that?
I don't think that it does, because it misses what I describe as the necessity of the causal connection between the information provided during the acquisition negotiations and then the actual hiring that took place. Without that, there isn't any breach of this contract, because under that suggestion, Your Honor, that you are making about the hiring, does that contract mean that for instance, LG Evans can't hire anybody from AEY no matter what the circumstances for the period of a year?
But if the information, just hypothetically, if the information provided does include information about key employees and identifies Hill, would that change the scenario?
I think, fairly speaking, that some of that information may have been there, but the record shows that my client, after he contacted AEY and said, we're not interested in purchasing, he shredded it all, including the confidentiality agreement. which then means that when subsequent to that, Hill contacts L.G. Evans, Jeff Swan at L.G. Evans has no idea that Hill would be someone who would be on that roster, and he doesn't have the roster. Let's call it the work roster, who your workers are. L.G. Evans doesn't have that stuff anymore. And so, yes, at the time that Michael Hill shows up, Hill says, well, this confidentially in LinkedIn, I'm looking for a job. It's not only you, it's other people that I'm looking for a job with as well. And I hope we can keep all of this confidential. But at no point in time is there any evidence that Swan, L.G. Evans, or anyone went to this package of information that had been provided and subsequently
And that causal
shredded.
connection is necessary, is your argument.
And I believe
Let
that
me ask you one other thing before we get to that. There does seem to be a bit of a lumping in of some of the other causes of action that might have gotten swept up in the motion to dismiss the complaint. And specifically, I'm thinking of the second and sixth causes of action, raising allegations related solely to the defendant's breach of the confidentiality, which is distinct from the hiring and solicitation argument. Your opponent says they kind of got swept up, and these causes of action should survive.
Well, I was thinking about that, and I went back and I tried to find a case from the Fourth Department, and I actually found one from 2017, and it's Gerber versus Empire Scale. It's found at 147 AD 3rd 1434, and this is a summary judgment case. And this is what helps me think about the idea that when AEY brings summary judgment, they have to prove a prima facie case, and then L.G. Evans has to turn around and show that there are issues of fact, right? But then when we turn it around and look at it from L.G. Evans, if they're going to bring a motion for summary judgment to dismiss, they have to bring up some sort of prima facie case, and then that has to be rebutted now by AEY. And so this is what has happened in the Gerber case, and I'll just read a brief portion of it. In the Gerber case, the plaintiff sued the defendant for violation of a disclosure agreement. And this is what the court said. Defendant who has been sued but brought a motion for summary judgment. Defendant met its initial burden of establishing its entitlement to summary judgment, dismissing plaintiff's first cause of action, alleging a breach of the party's non-disclosure agreement. Defendant tendered evidentiary proof in admissible form that it did not breach the agreement, a necessary element of a breach of contract cause of action. Although the affidavit submitted by defendant contained some hearsay statements, defendant established through non-hearsay evidence that it did not use plaintiff's confidential information to solicit plaintiff's customers in violation of the disclosure agreement. In opposition to the defendant's motion, plaintiff failed to establish the existence of a material, triable issue of fact. And so that helps me think about how these different things move around when different sides bring the different summary judgment. But to then specifically answer your question, there's nothing in this record which demonstrates there is a causal connection between that pile of information and anything else that took place.
We'll take a look at that, Counsel. Thank you.
Thank you.
Case 293, Dixon versus Zielinski.
It's just taking an extra moment, Judge.
That's fine, thank you.
We have him on the connection, but he's not responding, so we're not exactly sure if he's stepped away or not.
Okay, we'll give it, can we continue to reach out to him and we'll give it a few more minutes?
Will do, Judge.
Thank you. Mr. Handelman, would you unmute your speaker, please? Very good.
Okay, if it please the court.
Proceed, counsel.
My name is Martin Handelman. I represent the plaintiffs in this action. Basically, the claim of the plaintiffs is that the defendant breached his fiduciary obligations of self-dealing in three ways that we've documented. Without notice of consent of the general or limited partners, he awarded himself a significant salary. And he paid legal fees for unrelated services, and he contracted with himself to pay $4,000 to lease to the corporation a backhoe. These are breaches of a fiduciary obligation of self-dealing. The easy one, of course, is he contracted with himself to buy a backhoe and then lease it to the corporation, and without question received four $1,000 payments from the corporation for the lease of the backhoe. There's no question that he hired the Gallo and the Langelo law firm to represent him. And he billed all of the billing to Easy Mini Storage. Now, we have here family corporations, Easy Mini Storage being one of them, and that's owned by a number of the family members. And then we have 1000 Howard Road and Easy Excavating Company. Those were owned jointly by Elliot Zielinski and Earl Zielinski. Elliot and Earl had a difficulty between them, and in a prior lawsuit, Elliot and Earl were faced with the division of a warehouse that is connected and are in two parts. The warehouse has nothing to do whatsoever with Easy Mini Storage.
Counsel, can I ask a question with respect? Do we have a court-appointed expert in this case? Counsel?
No.
Mr. Thaney, who was Thaney?
Mr. Thaney was brought in not as an expert. He was simply brought in.
Who brought him in?
Well, we both agreed to have him look at the actual basis and advise the court, advise the counsel, really not the court, but advise counsel and try to bring this to a head. Mr. Thaney, however, never talked to Elliott, never talked to any of the defendants. And a lot of the, excuse me?
Counsel, there's a question.
You brought in Mr. Donovan after that, a certified fraud specialist, and he didn't find problems there. Isn't that correct?
Mr. Donovan and Mr. Thaney were brought in to see, Mr. Donovan, his sole purpose, was brought in to see whether or not there was actual looting of accounts receivable. And he went through all the accounts receivable and he said, he's accounted for the money that's coming in. Actually, if one looks at the complaint, we never complained that he in any way stole or dealt in a legal way with any of the income. The issue, of course, is with Mr. Thaney, is he did not talk to the defendants, the plaintiffs, I'm sorry. And the issue is he assumed facts that simply aren't correct.
So your argument is that the court relied upon that information inappropriately?
Very inappropriate. I'll give you some examples. Mr. Zielinski, Elliott, and Earl both received a salary from originally Easy Excavating Company and now by 1000 Howard Road. Okay? So, and Earl's wife, and prior to that, Alicia Tarkaki, actually did the work for Easy Mini Storage, which is one separate company, and 1000 Howard Road or Easy Excavating Company as another separate company. Now we have her being paid. We've got two companies that she's working for, his wife. But she's only paid by one company, and that company.
We understand the facts, counsel. We understand that's your argument, right? That she should have been being paid by both companies because she was doing work for both companies, and she shouldn't be paid, and it's improper to pay her out of the one company while allowing her to do work for the other company. We understand that argument.
Okay. So that's basically the argument. The next question is, can Earl Zielinski unilaterally by himself, I'm worth more money, and decide to collect the salary of $800, approximately $45,000 a year?
And the question becomes, what's the right value for the work earned? And there was expert information or opinions offered that the court looked at, but you dispute that, and you say that it was too much.
Well, first of all, again, we come to the expert information. Mr. Thaney says, okay, 40 hours for Easy Mini Storage is a fair salary, but he's also working for 1000 Howard Road. 1000 Howard Road has 100 parking spaces that are occupied, a warehouse building that's occupied. Why is he allocating one or the other? Where is he spending his time?
Yeah, and you put that evidence before the court, and you think the court got it wrong. I think we understand that argument also, counsel. You should begin to wrap up.
The issue, again, is his breach of, basically, his breach of fiduciary obligations. And the court below said, well, under the general business judgment rule, he can do it. The court is basically saying he, without justification and in violation of the agreement, and I just would like to wrap up by saying the agreement says he gets 2% for his work for easy money. Doesn't. But it adds in at the end, but if there's, and that's his total salary. And he has to look to the profits of the corporation or anything else. However, in this situation, he tags on to the last sentence, which is contradictory to the first sentence. This is in our reply brief. And in that, he ties in and says, well, it's necessary because this fellow Gauga quit. Well, in fact, that's not true. We have his payroll records for periods of time. And of course, we have records indicating that Earl Zelinsky could hire anyone and did hire anyone, including his son.
Counsel, your time is up.
Okay.
Thank you for your argument.
Good afternoon, Your Honors. Craig Chartier on behalf of Respondent Earl Zelinsky. I first want to address the salary issue in the partnership agreement. Earl's salary wasn't self-dealing. There's no breach of fiduciary duty because the salary was expressly authorized by the agreement. The language in the agreement is clear and unambiguous that he can pay himself a salary. It can be taken without the restrictions that have been urged by the appellants. The only restriction was if there was money available to pay it, and that's not at issue here. It could be done without the approval of the other partners. There's no need to look to any of the limited partners because the agreement expressly provided that they don't have any rights to engage in the business. Significantly as well, when we move on to the accounting looked at Earl's salary, it looked at his other actions, it was comprehensive, it was done by the party's joint expert, Mr. Thaney. It confirmed that all of Earl's actions were proper in all respects. The only other expert, as the court pointed out, was a certified fraud specialist that was brought in by the appellants. Also found no wrongdoing. There's no credible evidence at all that contradict anything in the accounting. It found that, well, the other thing the accounting did was specifically address all the issues that the appellants had raised. They raised them in writing to the accountants, or to Mr. Thaney, ahead of time. He went through and looked at every one of those issues. Every one of those issues was dispelled. The salaries were reasonable, Earl's and his wife's. The expenses were business related and expected. That included the attorney's fees. That included the backhoe. In short, there's no issues of material fact here. The court below got this correct. We ask that the court affirm that decision.
Thank you, counsel.